So I started the recording, and this begins our rack number 2. I'm kind of anticipating that we'll have one more rack after this, which will essentially be a discussion of the outcome of these first 2 discussions. I'm going to be working with staff over the next week or 2 to kind of put together a red line reflecting our own concerns and issues, along with what's been raised by the rack. So we're going to try to reflect all of that to the best that we can. And then we will circulate it to the rack. The rack will have a chance to look at that red line, provide comments and feedback. And then our next rack will be a discussion of that red line. So let's see. All right, so let's get started. Does anybody have any questions before we get started about how this is going to go, or any thoughts or concerns? If not, I'm going to dive into it here. Still don't see Irene. Okay. All right, so can everybody see okay? Let me make the text a little bit larger. Is that?
Looks good.
Okay. All right, I can't see what you can see. Okay, so we're just gonna go. I just figured we just go through this line by line, and then once we get to the end, depending on how much time we have, if people have additional concerns that they had or thoughts about how we can improve the contested case rules that are not in this list, then we'll get to those, and then once that's done, we'll switch to the overview of the proposed switch to the OAH model rules. So this first rule concern was raised both by Irene and Jim, and it deals with the kind of clarity around the sufficient specificity concept. So I think that's potentially Irene joining us. And the idea here is, or the concern, as best as I can get it, is that it's kind of confusing to participants about what they need to do to kind of meet the standard and actually, proceed in a contested case as a limited or full member. So I'm curious. I don't want to characterize the proposal, so I was hoping that either Jim or Irene, who had ideas about what we could do, could kind of share their thoughts about how we could improve the situation so that participants were better equipped to present their case and kind of meet the standard, should the facts merit it. Jim, did you want to go first? Or anybody else who has any thoughts? Elaine, go ahead.
Yeah, I do, sorry. But I'm just sorry for interrupting. I'm just texting sure. Irene. She has lost the contact information, so I'm texting that to her. That's why I'm a little bit absent-minded right now.
Okay, well, all right, we'll let Elaine go. She raised her hand. Go for it, Elaine.
Hi, good morning. Sorry, my camera's not working for some reason, but I also think this is of an interest to the applicants or the certificate holder too. Because one of the things that I think is frustrating for all parties involved is that from an applicant or certificate holder side is that it seems like the bar is really low, that someone can just mention something on the record and then they can argue it fully during a contested case when it hasn't been argued with any level of specificity below. And I think, Irene and Jim may have kind of the opposite view of like not needing to be that robust, but from an applicant standpoint, and I think the DPO hearing process is supposed to narrow the issues rather than have the issues explode when you get to a contested case. At least that's just my perspective. Thanks.
Yeah, thank you, Elaine. So it might be helpful for me to kind of, before we kind of get through these, I kind of had a little bit of a preamble here of kind of the direction and kind of the frame of mind that I'm in as I'm approaching each of these issues. And one of those, and the primary one that I think is important to remember, is that FSEC is set up in a way that if an applicant kind of meets the standards and meets the criteria and jumps through all the hoops, we have to give out a site certificate. I mean, it's in the statute. So I think that can be a bit of a challenging kind of concept for people to grasp, is, especially if they're deeply impacted. Maybe a project is going right near their property or through their property even, perhaps. And, it's sort of can be difficult. And I totally get that. But at the end of the day, kind of the mode for addressing what projects should be allowed and should not be allowed was done by the legislature when they set up the standards that we have to kind of abide by. So FSEC is not designed to kind of make decisions about what projects should go forward. We are a kind of a regulatory body that's kind of, we're supposed to be like a well-oiled machine, and that machine is supposed to look at data, match that data against the criteria that we've been given, and then make a recommendation about whether or not the data meets the criteria. So in this particular case, yeah, I would agree with you, Elaine, that we should be focusing, the whole point of the sufficient specificity standard is that we want applicants to be able to address the issue in the proper time frame. And, I'm not the authoritative person on this, but my feeling on this is that, and I'd be interested to see if there's any other perspectives, that the contested case process is no, the council's not perfect, staff's not perfect, and so obviously there can be disagreements about whether or not proper decisions were made. But to the extent that someone is concerned about a given standard not being met, it's optimal to get that addressed at the DPO phase rather than kind of use the litigious side of things to kind of battle it out. If we really want projects to go forward that meet the standards, let's do that, and let's figure out how to resolve that in the most efficient, economic way that we can. Go ahead, Jim.
Thanks. I have a little bit of a different perspective.
Sure.
One is that by the time we get to this point, the applicant and staff have gone from the notice of intent through a complete application. So therefore, there's a huge knowledge base that's built up between those parties, and the public does not have the advantage of that when it comes time to the public meetings and commenting with sufficient specificity. A lot of the times, that information is relatively new and fresh, and the people haven't been able to go through and read it to understand all the implications that there could be as you move down the road in the case. Now, a proposal that I would have is that when a notice of intent is filed, staff do a series of RAIs, requests for additional information, of the applicant. It would be nice if when a public person files a contested case request, that a similar RAI is done between staff and the public petitioner. This way, staff is helping to get that comment in as clean and as clear a form as possible so that we can move forward without the dancing that occurs afterwards trying to include things. One last thought is have some concrete comments to show people. I know in our Stop B2H case, there was one clear incident where staff and council refused an issue, but the council upon meeting knew what it was and felt that the individual commented in sufficient specificity. So kind of a couple of things to unwrap there is the footing's not equal moving into a contested case. Staff helps the applicant sort out their issues so it's clear. Staff should do similar for the public that are filing for a contested case, and that there should be adequate time for people to process that. Thanks.
So there was a lot there. And sorry, there was somebody else who raised their hand. I didn't catch that. Was that?
Yeah, Tom, that was me. But yeah, that was me.
Yeah, go ahead.
But if you got more to say, I can wait.
No. Go. Please go.
No, I would support Elaine's comments, and then as a utility would just add to that, anytime that an applicant has to go through a contested case, there's additional costs and time that all ends up costing everybody money. And those just add to the cost of whatever the rate base is going to be paying for that particular facility. And so, I think keeping that in mind as well, and understanding what you said, Tom, about how this is, you guys are there to help facilitate us to get a application and final order in a way that minimizes impacts to whether it's environmental or for the community all at the same time while supporting energy infrastructure is very critical.
Okay, sorry, Jim, did you raise your hand again?
I did, but I also see Sarah's got her hand up, so let her kind of add to the discussion before I
Sure.
throw in
Yeah,
my
it's really,
2
it's
cents.
kind of hard to see who's got their hand up. Go ahead, Sarah.
Thanks, Tom. This is Sarah Esterson with the Department of Energy. I just wanted to tee off of your idea, Jim, about staff kind of evaluating comments received on the DPO. I mean, I view that as a fairly challenging formal process to take forward, but what about opportunities where like people feel comfortable of calling the department and talking to staff about concerns they have and help, like that's what the analysts, that's what our team is there to do, to help the public navigate information, know where to go to look to find certain technical details or better understand conditions, or like is efforts by department staff to make it clear that we are there during that DPO comment period or at a completeness information meeting to answer questions about how to comment effectively? I mean, those exist now? So I guess the question would be, what are the barriers from your perspective of achieving your idea through that existing availability?
Well, a lot of it is, I think, the initial lack of understanding of the process, fear of asking a stupid question to staff because you're so new, or they're so new to the process. So I think, maybe a session for people that are interested on how to prepare comments with sufficient specificity with examples. Maybe a workshop like that. I know the OPUC annually does a thing about their contested cases, and they go through all the steps and the rules and try to take the magic wand and make something that's confusion a bit more clear to a layperson.
Ready for connection.
Well,
and I would just say that I think, for an application where we, as the department and our existing rules, have to do a notice of the complete application and a public information meeting on that complete application, that we can continue to, obviously we'll think and talk about the idea you just offered, but also additional opportunities at those completeness meetings for offering better information. We do try to do just what you're saying, and so we're just not hitting the mark because it's still, still unclear, I think.
Right, and I think that's where folks like us and some of the other community-based organizations can help get the word out that there is this assistance and ability to unconfuse a confusing process. But I'd also like to point out again is that the analysts and the applicant probably have worked for a couple of years to get to the point that they're at, where they're introducing the draft proposed order. The public has not had that time to research or the resources. A lot of the times it's coming at them on short notice. And, because the public's not sitting on top of the DEQ listserv, and the notification is so minimal. It's only 500 feet, I believe, in the county, and like, what's it, 250 in an urban growth boundary and 100 in a city, that doesn't notify a lot of people that will be impacted by some of these facilities. So the notice is weak, and therefore people come in late and are unprepared for the contest they're about to enter. So I think we need to look at leveling that playing field, and the utilities can hire all their attorneys and pass those costs on to ratepayers. The public has to take it out of their pocket, and that is an existing injustice and unfairness in the entire process. Those that have money can, do what they want, can run over those that don't. So that's what I'm looking to do, or try to represent, that we equalize the playing field and the time that the public has to respond.
So I have a couple of thoughts, and I'd be curious to hear if, what how the RAC feels about this. Perhaps Patrick could speak up to this as well. Maybe even Anne could share her perspective. But I mean, fundamentally, the playing field will never be level. This is not this is not a sort of like public-private sort of partner approach towards deciding what projects should be built and what shouldn't be built. This, the citizens elected members who became legislators, those legislators passed laws. Those laws set the criteria for what matters to the state of Oregon in terms of like the criteria for how we determine whether or not these projects should go forward. The state hired staff to make those determinations, and the enormous amount of time and resources are spent to then make those determinations go forward. My take on this, and this is a sort of a sticking point. It's a key point, and so I'd be really interested to hear other perspectives, because I am relatively new to this. I've only been working for FSEC for a year now. Is that the DPO phase, the contested case process, is really about engaging in the public to ensure that FSEC has done a good job. I mean, it's not always about mistakes. Sometimes there's information that maybe even an applicant, gets a study that's 2 years old, and it's the latest study that is available, and there's no reason to doubt its efficacy regarding the existence of like an endangered species, for example, in an area. But somebody who lives in that area is aware that there, has information that neither staff nor the applicant had. We want the process to be clear and easy enough that someone with that information can come forward and say, hey, I think you missed something. I have this information, I have this data that you need to take into account. And then the applicant can say, oh gosh, we weren't aware of that. They have an opportunity to respond, to look into it, and to deal with that new information. It's not the sort of like David versus Goliath type of situation where we're trying to figure out how we can empower the little guy to stop these projects. The projects either meet the standards or they don't. And if they meet the standards, they're going to go forward. That's just how the system is set up. So I completely am sympathetic to the idea that this is super confusing. I mean, I've been here for a year and I'm still figuring things out. So to ask members of the public, okay, you have 30, 60, 90 days, whatever the DPO phase is. But we're not asking them to become experts. If people are concerned about a given standard, whether it's noise or, protected areas, I do think that Sarah is maybe onto something here that, we should be focusing on. We want these site certificates to reflect the best information. And so if we don't have it, and if members of the public do, we want that information. We want to make it as easy as possible, as clear as possible. But it's never going to be, well, one site has a lot of power, so what can we do to make the other site have the same amount of power? That's just not how at least that's my perspective. That's just not how the system is designed. I'd be curious to hear if anybody else has any thoughts.
I've got a quick thought. Jim, I appreciate and the concern you have, and one idea that I have suggested to staff that they might consider is to create a template for making comments on a DPO. We have a template that staff created, I think, within the last 12 to 18 months. That is a template for a petition for a contested case. But really, as Tom said, we'd like to get these issues vetted earlier in the process at the DPO phase, with the hope that we don't have to go to a contested case, that if someone has a concern, we, along with the applicant, are able to get that concern addressed if it needs to be addressed to comply with the standards. We'd like to get that done at the DPO phase. So one idea I have is take that template that we have for petitions for contested case and use that as kind of a basis for creating a similar template so the public understands this is the type of information that would be useful to the department, to council, and to the applicant to have at that DPO phase. So that's one idea that I've had, and it's something that we might that staff might be working on.
Max, you had your hand.
Yeah, thank you, Tom. I just wanted to agree with your framing of this whole issue, and also with some of the suggestions that have come up. I think Jim initially suggested, and Elaine supported in the chat, the concept of a regular recurring workshop to talk about how to effectively engage in the process, how to demonstrate sufficient specificity. I think the concept of a form that was just discussed is also consistent with that line of thinking, sort of making the process more accessible. Also agree with what Elaine said in the chat, that that's not necessarily something that's going to be or would appropriately be enshrined in rules. They're great policy ideas. It's great that we have a venue to discuss them here now, and maybe this is a great group to continue figuring out how to sort of set up that scaffolding, but not necessarily things that need to be baked into rules. But just, I guess all of that summed up at a high level is really appreciate the discussion here, the way the agency is thinking about these rules and this rulemaking, and also everybody's collective efforts to come up with ideas for making the process more accessible.
Yeah, so just as I'm thinking about what I said and what you guys appreciate all the comments, really do. I just want to reiterate, our goal, our commitment is to fulfilling our kind of directive to the best of our ability. And so to the extent that members of the public are able to help us do that, and the process is confusing or is unclear or is structured in a way that makes that less likely to happen, that's bad. So if a member of the public has information that would be helpful in making it a more, better conditions or to improve our process in any way, then we should figure out how to make that happen. So I don't want to make it seem like, I'm opposed to public support, because I do think it's vital, because, the people who live in these areas, who are aware, they are on the ground. They're subject matter experts for, the land around them. And I do think they're a critical resource. And so we need to figure out how to tap that resource and how to ensure that the people who are affected by these projects are able to participate and provide meaningful participation. But that being said, what we don't want to do is design the rules in a way that allows people to effectively wage war against projects or to prevent projects from going forward, not because they fail to meet the standards, but because they don't want the project to go forward. And so I'm always, looking at each proposal with, does this make the process more clear, more efficient, more effective, or are we just making it easier for people to oppose projects they don't like simply because they don't like them? So that's kind of the line that we're walking, which is can be a tricky one, because sometimes what seems like efficient or clear to one side will, can be viewed as doing the opposite. Rudy, you've got your hand up twice. I didn't know that was possible.
I don't know how I raised it twice. Super sorry about that.
2 hands.
Yeah. All right. So this may be outside of the contested rulemaking process, but I mean, what I'm hearing from Jim and what I'm hearing from you all is there's this missing step of accessibility to the general public. So has ODO or any other Oregon agency really done any surveys to find out how best to get information out to folks? So there's this whole idea of messaging out. Are you saturating the affected areas or the affected communities with the information that these things are happening? So that's one thing to throw out there. And the other is, I'm not familiar enough with Oregon yet to understand if there's a plain language mandate. I know that many things need to be translated into different languages, but is there a plain language obligation on ODO to put out materials in a way that any person could pick that up and run with it? Because I think what I heard in the last session was, the affordability of legal support, being able to have attorneys. How do you get the public to know about what's happening and to understand it in clearer terms? I know at some point there's diminishing returns because of the technical aspects and sometimes the legal aspects of these things, but that opening of the door, is that something that could be worked on the ODO side of things, so the FSEC side of things? That's me. I'll put both my hands down.
Okay, Jim, let's hear it.
Just one point that I kind of wanted to bring out between the notice of intent and the DPO that occurs that the public often is not privy to are where staff make discretionary decisions with the applicant. For an example, in the case that I was in, because a transmission line was a linear facility, the 1 mile rule was waived and a 1/2 mile rule was put in place. Folks really were not aware of that. A second instant is around another case I'm in, around by a lake in the county that's a park. The transmission line was put right next to it. However, staff allowed the applicant to use older BLM and Forest Service studies to determine the effect of the view on the individual, where there were more current rules in place that superseded those old rules by a number of years. It's helpful if any decisions like that where staff are deciding things, if that could be highlighted so that the public understands that's not a rule, that's a discretionary decision by staff and the applicant to develop a methodology to measure something. In this case, it was the viewer's perception. Another instance was in the noise, the noise standards and how staff interpreted the rules, but the public was not privy to that interpretation, therefore unable to raise the issue with sufficient specificity because they didn't know what went on behind the scenes until too late. So another long rendition, sorry.
Yeah, that's a good point. I do think it's we should always be thinking about ways of keeping the public in the loop, because obviously if you're not familiar with how things are going or how the proceedings go, then you might not be able to, it's going to make it more difficult to engage meaningfully. I think we have a lot of thoughts on this one. I'm prepared to go to the next one. I know we could probably spend 2 hours on this issue, but it sounds like, and I'm certainly, if anybody has any additional thoughts and they want to, send them to me outside of the rack on this issue, as we start to work on the red line for this, feel free to do so. My takeaway is that, there's more we can do to, include, to kind of think about the public as we go through this process and how the decisions we're making and the complexity of the process could, impact their ability to participate in this process, and in ways that we could potentially involve them in sort of outreach, engagement. So some things to think about. Let's move to number 2 here, which is the issues around being a full or limited party member. So again, I'm gonna do we know if Irene is on? I haven't heard her speak. I'm seeing some phone numbers on here. I don't know who those folks are.
Okay, how do I speak?
Oh, you are on. Great.
I'm trying to figure out how to raise my hand too. I've had a heck of a time. I can't get through on my computer, so I'm on the phone.
Oh, that's a bummer. Okay, well, I will pause to give you a chance to comment, and in lieu of you raising your hand, because you did have concerns about each of these issues that we've raised. So go ahead, Irene.
Okay, on the notice issue, I have several concerns. One is that people are not buying newspapers any longer, or very few of them, and so I'm wondering about how to get the notice out. And perhaps one of the suggestions that I have was to expand. This would be a rule change. Expand the area notice, because when you're talking about a maximum of a 500-foot notice, people are directly impacted significantly beyond that. And so it seems to me that a half-mile notice to people who are directly impacted would make a lot of sense, or make more sense. This has always been an issue of concern, especially with the fact that, in particular in Eastern Oregon, there are a lot of us who have very poor computer access, or many people have no computer access, and they don't take the paper. So there is a real issue with notice problems. The other thing is, when the notices do go out, I think that oftentimes they are not clear as far as who is actually impacted or how they're impacted. And one example I give you is when they send out notices, oftentimes they will say things like, you received this notice for one of 4 reasons, and one of them might be because you're going to be affected by the noise from the development, or you're on the mailing list, or there'll be 4 or 5 different reasons why someone might get a notice, and it doesn't say what the reason is. So there's no way for people to really know why it is they're receiving the general notice. So that was a concern. Just as far as notice, I agree with Jim that there needs to be some way for people to get a more full explanation of the importance, in particular, of the notice for making comments, because I don't think it clearly tells people that if they don't make a comment, and they don't make a comment that meets certain specifications, they are not allowed to have a contested case on their issue. And I mean, there may be arguments about whether or not that actually is the case, but if you read over the notice, and I can refer to the most recent one, that it doesn't really state what people need to comment on, or what comments they need to make if they have a specific issue. And so that brings in the whole thing about specificity, and so I guess those are primarily my concerns with the notice. I'll let somebody else go and try to figure out now how to raise my hand here.
Okay. So so we're on the. Thank you for your comments, Irene. Definitely some overlap in the concerns here about kind of communication and reaching the public that we need to address. Mm-hmm. So for the second one about the nature of party participation, does anybody want to go to start on this one, or have any thoughts about this issue?
I do.
Go for it.
Okay. the nature of party participation, I think this is a real stickler for me in particular, and I think for a lot of other people, and that is Odo is moving towards making the public all limited parties, and the issues with that involve, number one, the short time frame for coming up with your comments, and if people have multiple comments, there may not be time to put those together. But the bigger issue, I think, is it's one thing to have limited party status for an individual, and it's another when you provide limited party status for a group or a group of individuals. And I would really encourage the RAC to include some kind of rule change which identifies when people can have full party status. And I'm thinking now about organizations like Stop P2H having limited party status, or any group of, say, 5 or more people having limited party status. When you have an individual making the comments and representing a bunch of people is, causes significant problems for that person to adequately represent them if they can't tie into other requests for other comments or other issues. And I'll give you one example that is really a thorn, and that is in the B2H original site certificate. Stop B2H and me as representing the public interest were given limited party status, and yet the developer in the course of the contested case submitted 4 different requests for summary determination. And those requests involved changes in the site certificate, such as removing the surveys for bats and allowing the surveys to represent more than one species. That kind of comment clearly can be of interest and concern to everyone, and nobody could comment on it because all of us were limited parties, and yet a recommendation was coming through this contested case that no one had commented on because no one realized that it was going to be an issue. And so those changes were allowed absent any comment from any of the other participants. So that kind of thing is what occurs when you have limited party status for all of the participants, and yet you have full party status for the developer and Odo. So that is the problem that needs to be addressed, I think. That's it.
Elaine. Yeah, thank you, Irene. Elaine, did you have a thought on that point?
Yeah, thanks. I appreciate Irene's comments, but I think it's important to reiterate that by the time we get to a contested case, I mean, this is like an adjudicated legal proceeding, and the issues are supposed to be locked in as of the time, you're raising your issue and then you proceed to contest the case. So I guess I just want to reiterate that, as I think it's important, and maybe Patrick could share a little bit from DOJ's perspective about how limited and general party status, full party status is viewed, but like the applicant ultimately carries the burden to demonstrate compliance with the standards, and the contested case is not an opportunity for people to continue to comment on how that applicant is trying to carry its burden.
Thanks, Elaine.
Sure, and I'm happy to weigh in on that as well. Our view is consistent with the Supreme Court's view. This was adjudicated in the B2H case, and Stop B2H in their appeal to the Supreme Court took issue with the fact that they were given limited party status, but the Supreme Court affirmed the manner in which FSEC and the department handled it. You have status in the contested case to participate on the issues for which you were given standing. You're given standing in a contested case based on the comments that you made at the DPO phase. To litigate a contested case, and again, the Supreme Court's, they pointed out, all of the issues that were raised were addressed. They were addressed by the people that raised them. To allow people that did not raise an issue to seek discovery introduce evidence, cross-examine witnesses. It's unnecessary because the person that raised that issue is already doing all of that. And to allow everyone to participate in each of those steps would make a contested case incredibly unwieldy, even more difficult, longer, complex than the B2H1 already was. And so our position, as it's been affirmed by the Supreme Court, is you get to participate in the issues that you were given standing on.
Thank you, Patrick. In the interest of time, I think we're gonna move along unless anybody else has any follow-up or thoughts about that one. I don't have anything to add based on what somebody said. Go ahead, Max. Go ahead.
Can I just respond to Patrick's comment there? Because
sure.
Two things occur in a contested case that really counters his comments. And one is that the ALJ doesn't necessarily allow everyone who commented on an issue to take the issue forward. So right initially, there is a question about, can someone else represent your interests? And so oftentimes people can have brought up an issue and yet not be present to represent their issue, and they're trusting that someone else is going to do that. The other thing is, when the comments about issues being brought up prior to the contested case, with summary determination, the issue may not, at least in the example that I gave, the issue of surveys and the methodology for surveys was never brought up by the developer until the summary determination occurred. And so no party would have known that there was going to be a request to change the site certificate conditions for addressing threatened and disabled, or threatened and for these special wildlife. Anyway, so that is a concern. It was not an issue that was brought up prior to the middle of the contested case.
Max, did you have something you wanted to
add? Yeah, just one angle that I think maybe has been missing so far and is important for folks to keep in mind, which is, as many of you know more intimately than I do, as I've not directly participated in a site certificate proceeding in this jurisdiction I have elsewhere, is that these are extremely detailed, complex proceedings based on lengthy filings with a huge number of issues, and they're ultimately being decided by a body of volunteers. I'm reminded of this partly just because I recently, had a conversation with the governor's office about how difficult it is to find people willing to stand for seats on the council. So I think it's really important to maintain the body's ability to keep some fairly tight control over how people are engaging with issues in a specific site certificate proceeding, and bear in mind that without the types of protections that we're discussing here, in terms of assigning limited party status to some potential interveners or denying intervention to some interveners, it's really possible that these processes would balloon even more than they are already inclined to do, and become, I think the word has already come up, unwieldy, just essentially impossible to manage.
Yeah, I guess my take on this is that the things that Irene is pointing out about how certain sort of like seemingly inadvertent denials can take place, I would say, the rules they're written to that purpose. It's not an incidental thing. It's not, it's not like we found a mistake that we're patching a hole here. The rules are designed to prevent people from participating. So it feels like, hey, why can't I participate? I'm being pulled out of this. That's because the process is designed to have some sort of level of, efficiency. And so we have to pare things down. The hearing officer has to make a decision about which issues can move forward, who actually raised a legitimate issue. We can't, if we didn't do that, people could say, well, I don't like this project and I didn't really have, I guess they met all the standards, but what can I do to make it not go forward anyway? I'll just raise 800 issues. And if I can get enough people, we can all join together and each, throw as many things as we can at the wall. And eventually the developer maybe will just give up, is a thing that we don't want to empower. And that's what the rules are designed to prevent, so that we focus on the individuals who have raised issues that actually have a basis in fact and in law. And those individuals we want to move forward. So of course they are granted an opportunity to have their voice heard. And for those who don't, then the system does not want you to proceed, because if we gave everybody that opportunity, then you could weaponize that, and then it would make this, as you said, Max, even more unwieldy than it already is. So yeah, I don't foresee. You'll see when we distribute the red line, but I'd be interested to see how you would change that language, Irene. But I think limiting people to the issues that they raised. We want people who are aware of these things to be the ones to fight them and argue them. It's not about, oh, I didn't know this was an issue and I also want to complain about it now. Someone else already did know about it. That's why they were able to raise it. That they're the one who we're going to empower to speak. We don't need to hear necessarily from every single person about the same issue. And as Patrick pointed out, the Supreme Court has already kind of weighed in on this. So in the interest of time, again, I don't mind spending a lot of time on these, but I do kind of want to get through all these today. Let's move to the next one, which is the scheduling issue. So I think maybe just to kind of tee this one up a little bit, having gone through these rules, and I wasn't involved in those contested case proceedings, so I didn't have, kind of firsthand experience about how they went. But my reading on the rules is that I don't know how else you would do it in terms of scheduling. So perhaps Jim was the one who kind of focused on this one. I don't know. Do you want to speak up? You mentioned in your comments that you were going to go back and look at what actually took place. Did you have a chance to do that? And do you have any kind of additional thoughts you want to add?
Unfortunately, I didn't have time to look that up, but I do have additional thoughts. Sure. Just more kind of in a process way, is that would it be helpful if the scheduling calendar, because that's kind of what this all comes down to, is this procedural calendar and when it's set, is there a way just to set the procedural calendar such that the issues will be decided and then a schedule will be developed based upon those numbers of issues and the workload? As I remember the Stop B2H case, is that the procedural schedule was set, but the issues weren't known, which seemed to create a very tight schedule. Now, I know the applicant wanted a very tight schedule to get done in June because they had to have the site certificate by July 1st of this year. But if my recollection's correct, I think if we could give more time to determine the issues, then set the procedural schedule with adequate time to develop all the issues.
Okay, well, I will look into that. Does anybody else have any thoughts on that one? I mean, we're already going to review that. That was the plan, to review the rules and see if we can address that concern. If not, I think we're going to move to the next one. Oh, go ahead. Sure.
I could add one thing to that. Just in terms of the schedule, there is I believe there's a statute that says that people will be informed of the process and what will be included, and things like summary determination and things like that would fall under that. And one thing that made the schedule even more unwieldy in the situation that as Jim has commented on, is the fact that there were things added to the schedule, like summary determination, that it was not even determined that that would be a part necessarily of the process initially. So I would like to support Jim's comment that says you need to know what the issues are to give you a sense of timeframes, but you also need to know as a participant what to expect in terms of timeframes. I mean, there were rebuttals and rebuttals and rebuttals and back and forth, and a lot of that was not clear, was never made clear to the participants. So it was a surprise over and over again about process. And so I'd encourage the rules to really require a listing of specifically what is going to be a part of this and what issues are a part of it, and then decide how long it's going to take to get it done. That's it.
Okay. Thanks, Irene. If anybody, unless anybody else has any other thoughts, we're going to move to the next one, which is defining or clarifying the process for informal discovery and filing of motions to the hearing officer. And to tee this one off a little bit, I will say that this one potentially is sort of addressed a little bit by the move to the OAH rules, which have a little bit more direction about how this process goes. So for those of you who hadn't had a chance to look at that comparison chart and or the rules underlying them, I do think that's highly relevant. Does anybody else have any thoughts beyond that fact they want to share on this one? Okay, well, let's move to the next one. So this one is defining or clarifying the process for requesting that the hearing officer issue a subpoena. So there's just lack of clarity in the rules about how to request or demonstrate that the hearing officer has the ability to issue a subpoena or when it's warranted. Does anybody have anything they want to add about that one that hasn't already wasn't discussed at the first meeting?
I just want to clarify that I did look into that on my part, and I found out that I was incorrect. I thought that in a case we had to go out to circuit court to get the subpoena, but in researching that one, the ALJ did issue the subpoena to compel somebody to give a deposition. So my memory was incorrect there.
No worries. Okay, well then let's move to the next one, which is, oh, go ahead. Sure.
I'm sorry, I can't raise my hand.
Yeah, no worries, just jump in. Yeah, just jump in, it's fine.
One source of confusion with the case that Jim's talking about is people requested subpoenas on multiple issues, and part of them, the ALJ had the authority to have a subpoena issued, and part of them she didn't. For instance, I believe with other agencies like Oregon Department of Fish and Wildlife, who people wanted to hear from, there was no authority. So it would be good to define with the issues of subpoenas under discovery exactly who is it that the ALJ is even able to move forward a request for a subpoena, because it's not just anyone. It's not just in the agency. And I'm still not sure exactly who they are able to and who they are not able to. Does that make sense?
That does make sense, although I'm definitely not an expert on that one, so I'd have to look into that. I don't know if Patrick has anything to say about that. If not, I can look into it.
If a non-party has information that's relevant to the contested case, then it's appropriate to issue a subpoena to them. As Tom mentioned, the OAH rules, which are suggesting moving to those rules, go into quite a bit more detail about the issuance of subpoenas. So I would encourage folks to look at those rules, and if there's anything that you think those rules don't cover,
let us know, but I think they're pretty thorough.
Okay. The other thing, and I think it's clear in the rules, it basically says that discovery is appropriate if there's anything that basically might have some relevance to the issue that is being presented. And there were multiple requests for discovery that were denied based on saying that the informal discovery had covered it, but yet it was really, it could be argued that there could be relevant information still that was not provided initially. So I think that, again, clarifying, I don't even know if it's a matter of clarifying, but just reinforcing the fact that for discovery, it is a fairly broad rule regarding when discovery is appropriate.
So I'm a little more versed in this. Having been an attorney for 7 years, debates and fights about discovery, at least in my experience, is 90% of litigation, because once you've determined the kind of universe of facts, it kind of, the outcome of the case, generally speaking, becomes apparent. Obviously, sometimes it doesn't, and things go to trial, but the battles usually are, the war is usually won in the battles over discovery. So the ALJs do have a lot of leeway in making those determinations, but I don't know that as a rulemaker, I'm going to be able to, redefine for an ALJ how they should interpret that rule. I mean, they are the paid experts in how to apply that. Not that they can't make mistakes, but I don't know what I could do as a rule coordinator to kind of change how that process operates. But we can think about it. And if you have any suggestions, Irene, I'd love to hear them. Okay. Elaine keeps getting kicked out of the lobby. Okay. All right, let's move to the next one. So this one is the kind of this suggestion that we adopt a docket system. And I guess I don't really want to spend a whole lot of time on this, because this is a sort of structural issue, not a rules issue. And we are sort of looking into, just sending a bunch of emails around is definitely cumbersome. So there's got to be a better way to do it. And we're, our hands are kind of tied in many ways. We can't, there's great solutions that are super expensive that we can't get. But we're looking around to see what we can do to improve over the existing things. So that was definitely a good suggestion to look at, Jim. I appreciate that one. For this next one, providing opportunity for interested parties to respond to staff comments to council. I didn't totally understand. I kind of get what you're asking for, Irene, but I'd love some clarification on what you think we should actually, how could we change the rules to allow for what it is that you're asking for?
Well, the issue really is around once the hearing is over, Odo is the one that makes the presentation to the council, and there are occasions where their interpretation is either not consistent with what the individual believes that they were commenting on, or what the issue even is, the definition of the issue, and there is no opportunity for the participant to have any kind of input into, wait, the important issue here was the important argument was this, and you completely left that out, or the restatement of the contested case issue is not consistent with what the issue is that I presented. And so sometimes things go forward before council with the council not having an understanding of what the real issue is. So this is kind of a two-sided thing, because the rules say that, for instance, that no one can have any input once the hearing is over, and yet FSAC has asked the developer to clarify things during their discussion of the comments, and so the developer can have an opportunity to respond and clarify, and yet the rules say that no one is supposed to. My thought is that the person who presented an issue ought to at least have a brief period of time to review the presentation that's being made to council and at least identify errors, which there are sometimes just plain errors in what is presented to the council. Right now, there isn't any chance to do that. So that's the thing.
Okay. Does anybody else have anything they wanted to add on that one? Okay. So this next one is the issue is providing an opportunity to contest or appeal an MSD ruling. So this is sort of related to what you were talking about earlier. I will say, Irene, with respect to conditions that change, that, you know, nothing is ever going to be, you know, in life is going to really fit every single situation. So these rules have to kind of be set up to kind of be optimal, which means that in some cases you're going to have outcomes that you're not happy with. But you picked that because if you went with something else, there'd be more outcomes that you weren't happy with. And in this case, you know, it's so unlikely that a condition would be changed at this point in favor of the developer. Usually what would happen is that if a condition is being changed, it's because an issue has been raised that the conditions are insufficient to kind of meet whatever the standard is. And so, I mean, the lack of opportunity to speak, I guess, I don't know. I'd be curious to hear if Sarah has any thoughts about this, or Patrick. It doesn't, I mean, at some level, you kind of have to, if you have a zillion chances to kind of interject, the process just never moves forward. And so, yeah, this is just one of those areas of streamlining where it's like, I feel like the error, you know, you kind of, like in science, you have like the two error types, right? So in this case, it's much more likely that a condition is going to be strengthened, not weakened. So the lack of opportunity to speak seems less significant here than it would be if, for example, a condition was to be removed. Like, you know, in that case, obviously the potential harms are a lot greater.
I think probably with this issue, one of the things this basically had to do with an ALJ decision, because I believe the rules right now do say that if a condition is changed, everyone is supposed to be able to comment on that, regardless.
Sure.
You know,
sure.
Limited party, not limited party. So the ALJ just made a decision to not allow arguments against it, which I personally think was not consistent with the rule language at the time. But so, you know, maybe it's more a matter of, I mean, I don't know how you deal with an ALJ that doesn't support a rule like that says everyone can comment on it. But that, I guess that just has occurred. Maybe it is not an issue for a rule change. It's an issue for, I don't know how you deal with an issue like that. But anyway, okay, thank you.
Okay. Anybody else have anything they want to add to that one? Okay. This next one was about increasing the scope. So obviously, if we increase the scope, I mean, that's not against the rules. We can increase the scope. We would go to council and say, hey, we've identified some additional issues that we think are related to this rulemaking, but outside the scope of what we originally proposed. So we think you should, you know, include these rules as well. I don't know that there's anything that I could think of that would fit this criteria where we would, I mean, I wouldn't want to just throw it out there. I would want to say, here's the specific rule language for this rule that would otherwise be outside the scope. I wouldn't want to just kind of open it up. We have to have a scope. So I guess for Irene, you're the one that raised this. For this one in particular, if you want to go down this road, I would ask that you would submit some actual rule language for what it is you want to change that's not within Division 15. Does that make sense?
I don't remember the comments that I made, so I'm having difficulty thinking about what was in my head when I made that. Can you read what I said? Do you have it in front of you, what I said, and it would?
Oh, you just said some rules are not found in the contested case portions of the Division 15 can be highly impactful on a contested case proceeding. I think one example of that is the sufficient specificity, which is actually not defined in 15, but is defined in 220. So we can't read, if we're not going to redefine sufficient specificity in this rulemaking unless we expanded the scope. But I wouldn't do that unless we actually had some rule language for that scope expansion that we were interested in. And
I think that was it. I think that was what I was no doubt thinking, is that Division 15 is a, it's a module, if you will, but does have impacts from the language and other rules. So probably not worth spending a lot of time on, actually.
Okay. All right. Well, let's move to the next one, which is about cost bearing. And we kind of covered this a little bit at first rack, but this is likely not within the scope of the rulemaking. Mainly, I mean, anything we would do with respect to this is sort of beyond the scope of FSEC in general. This is sort of a contact your legislator type of situation. We don't really have the ability to direct funding in this way. And the rules only have, or the statute, in fact, limits our ability to reimburse even other parties, with the exception of low. As you can see here, I quoted ORS 469 that, so they've spoken about this issue before and could certainly speak about it again. But outside of that, I don't see, and I guess Patrick or anybody can speak up on this if they feel differently, but that's my take on it.
Well, FSAC can propose rule changes, and actually it was Odo and FSAC that proposed removing the reimbursement for counties. So I remember being at an FSAC meeting where it was stated that FSAC should probably take more initiative in requesting rule changes when they are up against the barrier that they're not happy with in their decision making. So it's within the scope of FSAC authority to propose a rule. Whether or not they want to, I don't, that's another issue. That's it.
Anybody have? Yeah, sure. Anybody have any thoughts on that? Okay. All right, this next one, this is sort of kind of gets to the heart about what we were talking about earlier. This was raised by Elaine. Evaluating whether we can do a better job. And again, this is sort of by its nature outside the scope, but then again, it kind of does lend itself to illustrating why it's so difficult to deal with this in this context. Unless we're doing some, unless our suggestion as a RAC is a policy change, but making it more clear at the DPO phase that if people have issues with a project, that's the time to raise it, because that's the best time for a developer to deal with it and for that to be incorporated into the site certificate. It's a sort of like ounce of prevention is worth a pound of cure. We want to greatly incentivize people to raise as best they can the issue as early as possible. And obviously that puts a burden on people who aren't super duper experts to get up to speed incredibly quickly. But the alternative to that is that people kind of wake up to things way later when it becomes much more expensive to resolve issues. And so it seems, it's kind of an unfortunate reality, but as an agency, we have tremendous pressure to kind of make this process more efficient. And so to bog this down by not optimizing in this way, we'd have to have some very, very good reasons for doing so. But that doesn't mean we can't optimize and we can't make things more efficient given those realities. And one of those things could be looking at the DPO phase and figuring out what are things that we can do as FSEC to maximize understanding and improve the quality of participation at that phase, so we don't even go to contested case. People get their issues resolved at that time in one way or the other. I don't really have anything more to say on that other than the fact that we kind of, as we discussed in the sufficient specificity section, we are thinking about this and looking at ways we can engage members of the public throughout this process. Anybody else have any other thoughts on that one? We're almost on time, guys. Go ahead, Jim, do you have something?
I have a question there.
Sure.
What happens when one writes up an issue for a contested case, and then you find that the ALJ has reworded that to where your original intent or meaning is no longer clear? Where does one kind of go to engage in a dialogue to say, no, that's not really what I meant, the way you said that, this is what I mean?
Are you talking about how the ALJ is the one who kind of sets the issues for the contested case?
Correct. Like, an individual will write them up and leave, kind of a summary line on top, but you see the ALJ in some cases, the wording's changed, and therefore the meaning is changed, and the person raising it doesn't have an opportunity to say, hey, that's not what I meant, or do they have an opportunity to say that's not what I meant, and what's the appropriate forum for that?
Patrick, did you want to answer that question?
Yeah. I know that was, as you'll recall, Jim, we really spent a considerable amount of time in B2H kind of sorting through that. And we had pre-hearing conferences with the ALJ. So that's really the opportunities when we're having those pre-hearing conferences with the ALJ and framing up the issues to raise any concerns you have about how the issue's being framed. Another way that the department has tried to address that is through the template that I mentioned earlier, because it was very difficult for staff to sort through the many different issues that were raised by members of the public and try to frame them in a way that would allow them to be litigated in the contested case. So the purpose of the template, and again, the template I'm referring to is a template that staff has created that is for petitions for a contested case. If people follow that template, then the idea is that you will draft your issue in a way that can be litigated. So those are my two thoughts: are bring it, work it out in the pre-hearing. Hopefully you've done it already in the manner you followed the template. And if for some reason you're still not happy with the way the issue is being framed, then when we have those pre-hearing conferences with the ALJ, that's the time to raise that issue.
Right. Okay. I would love to see that template and to comment or participate in whatever way might be appropriate. But also I would like to say that at those pre-hearing conferences, we don't see the final wording from the ALJ. So we're not really haggling with the fine points. We're just discussing it. And then when they give that issue, it would be nice if there was some type of feedback loop to clarify that in case the app or the person raising that issue thinks it's not what they intended. And yeah, I don't know how to do that. I think as we go look at some of the model rules and stuff, there's some stuff in there that might be applicable to this discussion.
Yeah, it might. I on this particular one, though, I'm not certain that you will. I would say that that's something in the very first pre-hearing conference that you have to raise that with the ALJ, and so that's understood that you want to have the ability to review the way your issue's being framed. you know, at some point in time, as Tom has mentioned earlier, there's only so many things that rules can capture, and at some point in time, you just have to have the discussion very early in that first pre-hearing conference with the ALJ. So I would raise that and express that concern.
Can I add to that? And the one example that, you know, is with Boardman to Hemingway. I presented several issues, and what ended up happening is the ALJ accepted ODO's recommendations for rewriting those issues, and what it ended up with is, and I know I wasn't the only one with this, an issue was stated with supporting facts or documentation, which would be the documents or arguments that supported why the issue was brought up. And what ended up happening is the arguments ended up being issue statements rather than the broader statement of what the concern was. And that posed really significant problems because the issue was lost in the documentation statements. And anyway, I ended up not being able to really even recognize what my issue was. And I know there is statute that talks about the fact that you can bring in, actually I don't believe it's statutes, I think it's litigation that says an issue statement can be brought up, and in arguing it, the arguments regarding the issue do not necessarily have to be presented during the initial discussion or during the initial waive it kind of statement. So I think that looking back at the court decisions about the fact that an issue statement is a broader statement, the documentation or the facts supporting that are not the issue, you know, should not be listed as the issue. There are multiple arguments supporting a concern with an issue that is stated. Does that make sense? I hope. I can give you an example. Problems with mitigation actions that are when the mitigation plan is presented, there are problems with the way the mitigation plan is finalized. So if that is the issue, is the problem with how mitigation plans are finalized, then the issue is not, there's a problem with this mitigation plan, there's a problem with this mitigation plan. The issue is the process of finalizing those mitigation plans is faulty. That would be an example.
Yeah, I guess. Yeah, no, I guess that's just about having an open dialogue with the ALJ. I don't know that we could do anything about that in the rules. That would, in a way, that would make sense here. I mean, we give the ALJ a lot of leeway because the rules do. I mean, we don't dictate every, you know, millimeter of the process. We trust them to direct it. There are a lot of, you know, obviously a lot of rules that guide what they do and what they're allowed to do, but yeah, I guess I don't have any strong feelings or thoughts about this one in particular. Sarah, you had your hand raised? Did you want to say something?
Well, I guess I was just, I mean, it goes back to the idea Patrick brought up about a template for DPO comments, but it also, that dovetails into the kind of the issue that Irina is raising, where like the Department of Energy and Energy Facility Siting Council and ALJs, I think so far have interpreted that your issue at the DPO shouldn't change in your petition for contested case. But in B2H, both of which situations, you know, you were looking for a short and plain statement of what the issue is. to again afford everyone an opportunity to evaluate that issue on the record of the DPO. But then what we see is then it shifts in the petition for contested case, and the idea of a short and plain statement to many is, multiple pages. And if that differs from the comment on the DPO, where we might as staff been trying our best to figure out how the petition aligns with the DPO comment, maybe both of which were very lengthy, it becomes just so challenging I think that if to create an issue statement that for anyone that represents your issue. I mean, that was, we had people working weekends, holidays, living in hotels to try to evaluate what those issues were in a way where we could figure out how to then evaluate them. So I'm just validating that it's something that, I would hope the templates are a way to start, but we can't, we've in our, at least from a policy discussion, sort of said, well, we can't make people use the template. We can offer it as an option, but we can't force people to use it. But I think it just goes back to how can you take a big issue that the process of finalizing this mitigation plan isn't adequate. That's not loaded, but that's huge. And what does it mean? And were we clear on the scope in the first place? But how do you, that could be an issue with 10 sub-issues, which also makes the whole process challenging. Are you arguing one sub-issue, or are you have an issue statement that has many parts, and it just creates challenges? But it starts at the DPO, your comments on an individual's comments on the DPO. So I think that's where we have to start, and acknowledging that's not in the contested case rules.
Yep. Thanks, Sarah, for that excellent perspective. I did not have to do any of that, so I do not have that perspective. So it's greatly appreciated. Okay, I think that's the list. That was the list of issues that was raised at the first rack and that were commented on in the additional comments that Irene and Jim submitted. Does anybody else have any other additional issues that they want to share at this time before we go and have a brief discussion about our decision to propose the shift to the OAH model rules?
Hey, Tom.
Sure.
I would like
to
understand.
Tom, it's Sandy.
Hold on, Irene, one sec.
Mm-hmm.
Go ahead.
So, Tom, as a, certificate holder and past applicant, it seems like to me that the fundamental issue here is that you've got three parties involved during an application, and two of those parties, being typically the applicant and ODO, have legal representation, and the public doesn't. And my thought is that, just from a general perspective, one question I would have for Sarah is there recommendations on anything that goes out to the public that legal representation should be recommended in these situations? One, you would just get a better applicant, or not applicant, but a public argument coming in to help sort of streamline the process. But two, that, the rest of us have all got we've got attorneys that are helping us through this entire process. And it seems like to me, there just seems to be a misunderstanding or a lack of knowledge of the legal procedures within the application process of the public. And that may be the root cause of all of these major issues on any of these contested cases, or, getting people to get these issues raised during the DPO process rather than having them go to a contested case. And I would be interested to hear from Sarah on, are there recommendations, and then also Patrick and Elaine's input on
that. Yeah, I mean, I might lean on Patrick here. I mean, I know our process talks about what a petitioner needs to do to notify us of representation by an attorney, but I think we've, from an accessibility perspective, like, you know, certainly don't require it, and try our best to be like, well, we're trying to make it so that you don't have to be attorney represented. But yeah, no, I mean, it's a good point, and I think one that Jim and Irene have expressed as well.
You know, so then, you know, from my personal experience and having going through the family law system and having to hire an attorney of my own, you know, I remember early on having to go, I believe, to the DOJ website, and there was a list of basically legal services that were either free or pro bono, or, you know, or, you know, or there were some recommendations there as to where to go. And so I'm wondering if that's a possibility, you know, you know, for me, and like I said, the two attorneys that are on here, I would like to have their input on this, but it seems like if the public side that's coming in would have representation, you would just get a better quality of arguments, and they may be able to, you know, like, hey, you know, that's not really an issue we can bring up, you know, that they're really looking at what's in the standards, and from a legal perspective, what can be brought up and what can't be brought up. It seems like at this point, things are just being thrown, like spaghetti being thrown at the wall and seeing if it's going to stick or not. And it's very frustrating for all of us, ones that are having to defend that, but then also the public side, there seems to be a perception that everything's being denied at the same time. And, you know, it just seems like to me a legal representation there would help facilitate this a little better.
Yeah, I certainly agree. In the contested cases that I've handled, the ones where petitioners are represented by counsel go more smoothly. But as Sarah said, you know, we can't require people. So what we're trying to do is, and that's one of the purposes of this rulemaking is to make the process more understandable to the public. There is one rule that we have that allows, if people claim indigent status, then they can have costs waived. So for example, you know, costs of getting copies of documents or issuing a subpoena, but we don't have, you know, obviously we don't have funding to pay for the public to retain private counsel. That would have to be something that the legislature would have to authorize, and I'm doubting that would happen.
Yeah, and that's not what I'm asking, but you know, but maybe, you know, and just what I'm getting at is like, let's make it very clear to the public that, you know, all of us that are applying for or regulating this process have attorneys involved, and this is a very legal intensive process, and that the recommendation is that, you know, there's maybe some understanding or some expectations set early on that if you decide to go on this on your own, that, you know, that it's going to be, you know, labor intensive. And it sounds like, you know, Irene and Jim have experienced this, but that, you know what you're going into and make sure that you're prepared to get, you know, comments in and understand the process, that, you know, understanding that the applicants and AppSec and Odo have attorneys already there that are, you know, the process is equally as cumbersome, well, not cumbersome, but equally as complicated for us as well.
Can I comment from a user perspective? Really, when you start talking about the costs of an attorney, you preclude the participation of a huge audience out there as far as impacted folks. And I would really like to know where these free or pro bono folks would be, even to get a consultation which actually it might benefit the developer to reimburse for at least consultation expenses for someone to determine if their issue has merit. I can tell you right now, I am searching for an attorney to represent an issue, and it is not easy, even when you're willing to pay for the representation, to obtain an attorney to represent an issue before a developer and FSAC. There are very few folks out there who are willing to put them, I mean, I'm talking attorneys here, who are willing to put themselves in the position of arguing against the state agency and a developer. So between the cost and just having access or having a list of attorneys who are willing to at a cost represent a private party or a nonprofit is challenging.
So Irene, a number of years ago, this Oregon State Bar environmental section, it's the environmental and natural resource section, maintained a list of attorneys in the environmental arena that were willing to do pro bono work. I don't know if that section, I'm no longer, I was on the executive committee of that section for several years. I don't know if they're still maintaining that list, but that one place that you might start is ask if that section is still maintaining the list of pro bono environmental attorneys. So again, it's the State Bar Environmental and Natural Resource section.
State Bar, okay. Thank you.
Jim, I see your hand is raised, but we need to, we're kind of out of time on this point here, unless you have something real brief.
I have something real brief for thoughts.
Sure.
We don't have a citizens utility board or intervener funding like the OPUC does. And I really think putting something together like that would be very helpful. And also, we're going through the right siting. I believe the legislature charged ODOE with wind and solar right siting to come up with sets of rules. I think with that ongoing, something like CUB for this group, I think would be ideal, and would love to work with the agency to put forth legislation to make it so. Even some of the counselors of FSAC have said that intervener funding might be a good idea. So I'll leave it there.
Okay, thanks, Jim. All right, well, just had a couple minutes. I didn't really, I wasn't planning on going into the weeds on the, let me just pull it up real quick. Just wanted to more give you some ideas on kind of reviewing it yourself. But essentially, there's a couple of reasons why we're switching. I would say maybe one of the main ones is that we have typically been using ALJs from the OAH. So it makes sense to use the rules that they're familiar with, and as opposed to the model rules. The kind of secondary reason is I've kind of just in going through this, I mean, it's not, I bolded some sections here, and I guess I could send this copy to people, but all I did was bold any spot where it says that the OAH rules contain, additional language regarding this issue. So, in doing a comparison, we just discovered that the OAH rules have more detail, have some more clarity with regard to not all of these. And, a lot of these are the same, or there's no meaningful difference. But like with discovery and with subpoenas, there is, especially in those areas, there's a lot of additional language. Like here we have, for subpoenas, OAH rules allow a party to file a motion to quash a subpoena, and there is no specific provision for that under the model rules, which isn't to say that you couldn't create a rule, and we can modify or adapt our rules, which we have done after adopting the model rules. But rather than do that, it makes sense to start, or I should say, in addition to doing that, we should start from a template that the hearing officers that we're employing are familiar with. So just kind of wanted to encourage you to look over this. This isn't going to be in the red line per se, because the red line is just going to say, before it said we incorporate the model rules found here through here, and now it's going to say we incorporate the OAH rules found here through here. So the red line is not going to break this out, which is why we made this chart. So definitely, to the extent you have any thoughts or feedback about this particular switch, please do use this chart as kind of a guide, and to the extent that you are concerned about this particular issue, definitely dive into the rules in 137 here to see exactly what the switch would entail. But we feel like it's a pretty good switch, and having gone through these, I definitely support this move that has been suggested. And does anybody have any questions about this particular proposal or concerns?
I like the idea of, Irene here.
Yeah.
I like the idea of using some existing rules that have been applied and used by a broader audience, just in terms of interpreting and understanding what the rule language means. So that's my comment.
Yeah, sure. And that's definitely part of it. So we're hoping for some efficiency gains here, in that the hearing officer won't have to spend time and energy trying to understand how to adapt rules that they don't traditional or have used on a regular basis. So they'll have a better understanding, and to be able to communicate with the parties more clearly about how the proceedings should go, so there's less confusion. Yeah, Max, go ahead.
Sorry, this is not particularly helpful, but just planting a flag that I haven't had a chance to review what you sent around yet. So I'm saying if I spot something later, I'll bring it up either in writing or at the next meeting.
Yeah, I would consider. So again, I'm going to be taking the feedback that we've received here and meeting with Patrick and Sarah, and we're going to be kind of generating a red line that has all of the changes that we feel are appropriate and good and optimal. And this is one of those changes. So when we ask for feedback on that red line, it would include any of the changes that are in the chart that we circulated, which is sort of an overview of what we're going to get by switching from one version to the other. So before we go too much further, I wanted to give an opportunity at this time to any non-RAC members who have 2 cents, maybe 3 cents they want to throw out to the group for us to consider, especially at this critical time as we start drafting the red line. Anything you want us to kind of take into consideration as we embark on that effort? Nobody has to say anything, but now's your chance. And of course, you'll have opportunities during a public comment period and a public hearing to comment on anything that we generate as part of this process. So now is not your only time to speak up. All right. Well, I'm not seeing any thumbs up. Oh, go for it. Yeah.
Yeah.
Alex,
it's Alex. Alex
yeah, go
Joe
for it.
here. I'm hearing that there's some opportunity at all stages, it seems, to evaluate the process as you go along. Maybe not after these rules have been put in place, but as these team meetings line up. And I'm concerned that there may be focus groups, maybe committees or some other form of review that might exist just to be able to process information that might be specific to a case or general in nature, as you mentioned earlier, just for the sake of having a process that does work, that would move forward. So how do you maybe look into the existence of an off-site or standing committee that might work to that effect, just to do a review as needed.
Are you talking about a review of the rules or a view of like community engagement?
Well, it could be both, but specifically to this conversation, it probably would be rules, unless, they're in place and then they're set in stone.
So anybody at any time can reach out to me and say, I'm not happy with the rules, or I think we should change these rules. We have a list, a working list of kind of future potential rule changes. So we do not have, outside of these RACs that are implementing, the various rule changes that we want to engage in, there isn't, sort of a formal body that, I'm the rulemaking coordinator for this group. So I'm the body. So if anybody has any thoughts or concerns about the rules, they hit my email and my phone number on the website, and people can reach out to me and say they're not happy with how things are going. And to the extent that people identify, issues and things that we can change to make things better, becomes something that I present. I'm actually going to be presenting to council in December our proposed schedule for the next 2 years for what our rulemaking should be. And, I do that analysis based on what people have submitted and the conversations I've had. So I don't know if that answers your question, but we definitely have a mechanism for people to engage, but it is not necessarily a kind of sort of standing committee, as you said. It's me, for better or worse.
Okay. All right. Thanks, Mr. Jackman.
Yeah. No, it's a good thought though. Okay. All right. Well, does anybody else have any last things they want to say before I talk about next steps? All right. So yeah, again, as I've kind of mentioned earlier, I'm going to sit down. I'm going to go through all the comments that were made today and the materials that were submitted, and going to incorporate the things that were said as best as we can, with kind of the caveat or the understanding that or at least my MO is that we want to make this process, we want to ensure that we protect the citizens of and the resources in our great state of Oregon, and we want to do it in a way that does not waste time and resources that do not need to be wasted to achieve that goal. And to the extent that we can identify ways to improve these rules to achieve that goal of providing energy resources in the best way and in the most optimal way that we can for the state of Oregon, that's what we're going to do. So if any suggestions have been made, and you feel free to reach out to me in the coming days. And obviously once we submit the red line to the RAC to review, if you have any ideas on how to do that, it's gonna show up in our work product. But that is kind of the main thing that we are operating under. I just also am super grateful for all the participation. There's a healthy group of people here that attended the RAC today, and so a variety of commenters and thoughts that were shared. It definitely helps me, just my own personal working style. I do my best work when I engage with others who force me to kind of reevaluate and take a look at my own thoughts and my own thinking. So I do greatly appreciate the healthy attendance here today, and I hope that you all are excited to get the red line. We're excited to get it to you, and that you have the chance to look it over and provide any feedback. Your feedback can just be, looks great, that's fine. But to the extent you have any thoughts or concerns or ideas about how we can make additional changes, please submit those. The plan right now, based on today's meeting, is that we're going to have one additional RAC. We're going to discuss the red line, and that'll be that in terms of the RAC. If there's a ton of suggestions or a ton of feedback and we can't even get through it because there's so much amazing, awesome feedback, we'll have a fourth rack. That's, I mean, it's not like we only have to have 3, but I just want to kind of forecast what my thinking is right now. I think we'll be able to get through it in just one additional rack where we kind of discuss we get to where the rubber meets the road, so to speak, and we see the actual language that we're putting out. But yeah, that's my thinking right now. If anybody else has any other thoughts, feel free to share them. Or you have my email, you have my phone number. I am open to any communication that people want to engage with me outside of this formal RAC meeting. But that is that. So I would say expect to see something within, I don't know, Patrick, Sarah, or Jim. You had one. You had a final comment. Go for it.
Yeah, just for the red line, what section of the rules is that going to cover? Is that going to be the entire, what's it, chapter 15? Or what will the parameters of that be?
So yeah, I guess I could give you the exact ones, but it's essentially so in Division 15, 345.015, starting in, what is it, 83?
Maybe what?
Sorry, yeah, no, it goes.
If you could just send us an email with.
Yeah, I'll just send you an email. But essentially, it's all the stuff in Division 15 that deals with the contested case stuff. So it goes, 1 through 85. So you're not going to have to wait too long to see it, and we will. Yeah, get that out to you. And when I do, again, I'll basically send it with a poll for, I guess I can send the poll now. I just don't want to lock us in. If we can always change it, I suppose. But yeah, look forward to a poll on just like we did for the first 2 on the best time for our next rack. And yeah, thanks again so much, everyone, for your participation. Really do appreciate it. I'm going to let you all go now. Have a great Friday.
Thanks, Tom.
Thanks, Tom.
Thanks. Be safe.